of Commerce, the media practitioner, women's organizations, and youth groups. And that the committee will make recommendations to the president. So the committee will vet candidates and then make recommendations to the president of persons who have met the criteria for appointment to the commission or to become chairperson of the commission. And then the idea is that the president will select from that list of nominees submitted by this selection committee. So yes, these are proposals on the groups that will be represented. I'd like to say I've been very public about it, that yes, this proposal went through some amendments, and we'll be happy to speak about that. Again, it's not set in stone, it's the essence of these discussions, so we get something better.
Can you please just kindly slightly explain a bit so we can
that will disadvantage some other people.
Wait.
Thank you very much. For the last time I remember, I'm chairing this meeting.
Okay.
Thank you.
Yeah, so this we propose will move and will be a new provision in the Constitution on inclusive search and nomination committee. Now, the current system, of course, we know is that the president appoints after consulting with the leaders of all registered political parties. But this has been a subject of debate. We welcome that debate. Political parties want to be represented instead of transitioning this to other bodies. There's concerns about how this will be constituted, whether the president appoints or whether the groups send their nominees. I think let's have those discussions. And this really lays out the mandates of the search committee to develop a job description, conduct a transparent selection process, and submit the shortlist to the president for appointment, and then the president appoints from that shortlist to go to Parliament. There's also a new provision that there should not be a requirement, professional and academic requirement for persons serving as Chief Electoral Commissioner to hold an advanced degree with 15 years of experience in electoral processes, public governance, law of policy, be of proven integrity, eligible for Parliament, not a minister, not a member of Parliament, public officer, or over 65. And then, of course, same for the other commissioners, but to say to hold a degree, of course, all of these from recognized universities accredited in Sierra Leone, and then for the other commissioners, 10 years experience and the various fields that we have mentioned, and of course, same format as I described in the previous slide. And then there'll be a transitional provision, really to say if persons hold office or positions within the commission right now, and then this provision comes into effect, they will continue to serve for the remainder of their terms. But then after that, subsequent appointments will be made in line with this provision. And then we said the same procedure will apply to the appointment of the chairperson of the PPRC. Same as I've described in the previous slides. And then, of course, same transitional provision. Then a proposal to rename the PPRC in the Constitution to read as Political Parties Registration and Regulation Commission. So this is the other provision out of the tripartite process recommendation 70 that proposed to deregister political parties that do not win local or national elections after 2 successive general elections. But then, of course, you know, we've said that this should be considered alongside the functions of a political party under Section 35 of the Constitution where the functions extend beyond winning elections. Again, I want to particularly put this in context. Yes, it came out of the tripartite committee. Because we did not want to appear to be deleting recommendations, that is why we put this here while stating government's position on this, which is that political parties exist for more than just winning elections. Political parties exist to also represent the views of the minority. Political parties exist to hold government accountable on several other issues, and so that is government's position on this. So whilst it was a tripartite recommendation, I think we've been very public that it's not a proposal that government is really going to support. We have taken a principled position that is here, collective responsibility from the tripartite process of coming into this being. This is not our position. I think we've been very clear on that. And then we have said that the provision in the Deepening Act should be reflected in the Constitution. This was a recommendation in the Cowan report. It was a recommendation made by the Truth and Reconciliation Commission. It was one of the 16 recommendations that women's groups submitted as being important to them, and it is one of those things that government is committed to and agree that the provisions in the Deepening Act should be reflected in the Constitution. And so we will talk about the building blocks to ensure that, yes, the other systems in place, other legislation reflect this, including constitutions for the political parties themselves. And this on the use of census data. That the Constitution be amended, Section 38, to say only data from the senior census will be used for electoral purposes. And that where the final report of a decennial census is published at or less than 24 months before a general election, that data from that census should not be used for the purposes of drawing constituency boundaries for use in that general election. And I think this is where we have also said, as a government, and we'll work with members of parliament, we're very open if they are on the need for a transitional clause for this particular provision. We're very open to that. It's something that we support. I think we'll be very public about that. And then, of course, these are the technical details of that amendment. It is also proposed that sections 41 and 42 of the Constitution be amended to remove the requirement for political party nomination to facilitate independent candidature for the presidency. We know it's a thorny issue, but we also note that it was a recommendation made in the Cowan report. It was a recommendation made by the tripartite committee, and also it's reflected in the one of 16 recommendations made in the Women's Manifesto. Of course,
Other honorable members, please.
of course,
Thank you very much.
Of course, we have also said in the bill that yes, the concern that this might open the floodgates, and then you have a lot of independent candidates, which will make the process hard to manage, is a legitimate concern. And so that is why in the bill, That is why in the bill that we have here, we have put in certain conditions. One, of course, we do not want someone losing flag bearership elections in a particular political party and then overnight just transitions to being an independent candidate. So yes, I think with members of parliament will have to put a clause on. We have said that the person should not be a member of a political party, but I think timing on that will be good to do. We have also said that the person must demonstrate sufficient financial and community support. Community support, and as prescribed by law, that will be prescribed in a separate law by parliament. And community support we do like you have in certain countries, verifiable registered voters to sign up and take a bet on that candidate. And then we have said financial standing as well to be determined by parliament to see. But we also note that really listening to public discussions or engage with various stakeholders, a financial requirement will eliminate very good and credible persons from the presidency, including women who should be able to participate in this process without these extra roadblocks being created. And that is why, in fact, one of the proposals we have in other legislation is really the removal or reduction of candidacy fees for women, and then of course other for marginalized groups. But yes, that is a provision that we want to have a discussion on and come up with something that will work for the people of this country. So yes, that will. And then we come to section 42.2. Our current system requires a candidate to put 55% of votes in the first round. Then, of course, we've had to deal with the challenges of runoff elections. In fact, someone brought to my attention that the runoff elections sometimes are even more problematic than those on the first round of elections. And so, in the constitutional review process, before the tripartite process, yes, it is reflected in the white paper that will move from the 55% threshold. And then, in the tripartite report, it was also recommended that we move from the 55% threshold. Now, when I talk about areas where both processes align, this is really one such area that we move from 55% threshold. Now, the debate has actually been whether it's 50 plus 1 or a simple majority. Say, right? So that has been the question. But then there is also the threshold. Because when we discussed this on the tripartite committee, we talked about moving from the 55% threshold, but I think we also discussed the need to keep this country together. And so that is why the tripartite report recommended that yes, you move from 55%, but you also have the threshold system. And yes, tripartite recommended that the candidate must also pull at least 25% of total valid votes cast in half of the voting districts. I think I've been very public to say that is what tripartite recommended. So 16 districts, that would be 8. But then when we discussed this, and again, this is not a surprise because, I have raised this repeatedly, that we have discussed this in the government, with all stakeholders, saying half of the voting district doesn't really solve the problem. because a candidate and political party will focus on their own stronghold and run the numbers there, which is what we really don't want. That's the problem that we're trying to solve. When we came up with the 25% threshold in half of the voting district, we realized that half doesn't solve the problem. And so our proposal, it's a proposal, I must emphasize. Our proposal in this bill is that reduce from 25% to 20%, but now in 2/3 of the voting districts. And so yes, we want our political parties to have national agendas. We want our political parties and candidates to have national appeals, to look beyond their strongholds. And that is why we reduce the threshold, but then broaden the scope of it to cover 2/3 of the voting districts instead of half of the voting districts. And then this, so the current law actually says 7 days, right? So the tripartite committee recommended was that where there is an election dispute, in an election where no candidate has met the threshold under section 42, that's to mean for an election that is meant to go into a runoff, then petitions should be filed within 3 days. If it's an election that will not go into a runoff, then the 7-day window prescribed by law actually is what applies. So this window applies only to an election that will go into a runoff, where a candidate has not met the threshold under section 42 of the Constitution. And then, really, we have had to deal with cases where election petitions take forever to determine, to adjudicate. Right? It's a complaint that we have filed, we have all made. And so, the proposal from the tripartite committee was that the matter must be heard and determined within 14 days. Now, of course, under the leadership of the two gentlemen I mentioned here, we did not just come up with these numbers. We actually also had a session with the judiciary on this to discuss what is feasible, and what will work in the interest of justice. And together, we arrived at these numbers. So they were not arbitrary, they were not the creation of the tripartite committee. But again, like I've said, these are proposals. I think let's all discuss, and then what comes out of Parliament should definitely be better than what we have put in the bill. And yes, this really lays out that yes, a person dissatisfied may file a petition within 3 days. And then once that is filed, the Chief Justice will notify the Commissioner, the Chief Electoral Commissioner. That's really Chief Justice is supposed to be representative of the court, and yes, I think at that level, in the context of elections, that's how correspondence should be exchanged in the office of the Chief Justice and that of the Chief Electoral Commissioner, not at the level of one judge informing other members of the Commissioner or the Master and Registrar. But the Chief Justice can give directives for that correspondence to be passed through the other administrative measures that are available within the judiciary. So yes, if no petition is filed, runoff to be held within 14 days of the notification. If petition is filed, the Supreme Court determines that within 14 days. And then, of course, if upholds the declaration, subject of the petition, then runoff to be held within 14 days. But then, if the court opposes the declaration, but then if the court invalidates the election in totality, then a fresh election will be held within 60 days. And of course, we explained the runoff process here, candidate getting highest and second highest where two candidates tie in the total number of votes, those two candidates will go to a runoff. But then, if an election is nullified, and then then the election should be reconducted within 60 days, then all persons who have participated in the first round of elections should be able to participate. That is only if there's a petition before a runoff and that election is invalidated. We have this again, amend section 43 and 87 of the Constitution to provide a fixed date for holding elections. Yes, we proposed second Saturday in November. It is to say, again, it is not set in stone, it is a proposal. We also acknowledge that prior processes, including the Cowan and the tripartite processes, recommended dates between March, April, and May. But yes, it is the proposal of government that the elections be held in November of every 5th year. Now, one thing that I would like to make clear is that we acknowledge that Section 87 and that of 85 are entrenched provisions in our Constitution. But then, as has been explained, when an entrenched provision is amended, it has to go into a referendum. Now, in the public discourse that we have followed, some have said that we have skipped the referendum and brought a bill to Parliament. Actually, we are still on track. This is the procedure. You bring the bill to Parliament. Of course, it's all laid down in Section 108 of the Constitution. And then, once Parliament votes, and the bill gets a vote of 2/3, that is when it goes to a referendum. So we're still on track. We haven't attempted to set any process, but to give this impression that because entrenched provisions are included in this bill, that means government is trying to play some game. It's misleading. I think it's misleading, and I think as leaders, we should do our homework and then be able to inform the public, especially people who want to govern in the right way. Again, the other thing that I must say.
You have to see that
Yes.
We are live on here. Please take your time to explain.
With leave of the leader of government business, SO2, as they say in Parliament, I'll explain this in Creole. Now, government no say, then section yasu, like section 87 and 85 of the Constitution na entrenched provisions. And for entrenched provision, it therefore go to a referendum. But the Constitution very clear. Before you take this to a referendum, you therefore bring come first as a bill na Parliament. Parliament they debate, a vote, and when that vote they come out, 2/3 in support of the bill or the specific amendment. Now that 10 day it will go to a referendum. So people around the talk say government don't count entrenched provision inside, so they don't go referendum. The referendum now the last step. The bill they come first na Parliament. Parliament debate, a vote. If Parliament vote for the bill by 2/3 members of Parliament, then it will go to a referendum. So if anybody tell the public say government don't count entrenched clause if we don't care go referendum, that person did not do any homework it. A misleading for the public. And that is why we don't be very open about this process. If person get question, you will ask, we will explain. We does them always open and ready for provide clarification. And not only for question. If person gets suggestion, you want count and to be, please do so. And we don't be open to suggestion. We don't take plenty suggestion throughout this process here. So. Now the other thing we are foresee. If anybody tell you say an entrenched provision and a non-entrenched provision not go dey inside the same bill for amendment, not to so the Constitution say. The Constitution not say where you dey come, if entrenched provision dey, you for kick am out first and can separate. The Constitution dey very clearly how you dey amend the bill. And then how you amend the Constitution. And then it adds here, if any of them provisions here so, they lay them out in the Constitution, need for be amended, after Parliament don't vote, it will go into a referendum. So yes, we are aware. One thing where we don't say very clearly, now that when we complete the electoral reform process, the proposals will touch on elections. Once we complete that, we will continue with the broader constitutional review process, where they lead me into a referendum. But we just want to make sure, see, all the proposals from both the Cowan report and the tripartite report will touch on elections, we bring them come as one package. Now then now with Parliament doing work, then we'll put transition clause and say so let me just wrap this up to say, that is where now Parliament can come and say, get transition provision. Say yes, this no would in a certificate. I think the Deputy Speaker of Parliament did an amazing job on 98.1 this morning explaining this process. That if this bill is enacted by Parliament, then the proposals that touch on entrenched clauses in the Constitution will not be part of the certificate that the President will sign. That certificate will only apply to non-entrenched provisions, because we are aware that entrenched provisions will go into a referendum, but at least we'll have taken out the elections-related provisions and then we'll move on. I hope that makes it clear. We have also proposed that in case a candidate is standing trial on a criminal charge to which the state is a party 1 year prior to election, such trial must be suspended until after election. This is something we discussed in Tripartite Committee, and we have put in here. This is the proposal. But if you look at the bill, we have also put additional layers to this, which is to say, like you have in other countries that we have looked at, persons who have been convicted for certain offenses cannot be made to run for office, but that restriction will expire 5 years after they have served their sentences. So it's not, you don't lock someone out of the electoral process for the rest of their lives. That is an addition I think will be very public, that it's something that we have included in the bill. And then, so this again has generated some form of misunderstanding. So here we're proposing that, and this is actually from the Cowan Constitutional Review Committee report, that we include in the Constitution that the loss of party membership alone will not automatically remove someone from, will not automatically remove a sitting president or vice president. Let's be very honest, that the Samsumana case is a clear example in front of our eyes, because that vote sits with the people. And so we're saying that that decision to remove a sitting president should not be taken by a few actors within the political party. We're saying that if that happens, then the existing provisions in the Constitution should apply. I know, of course, that part of the public discourse has been that we put in a new proposal to give Parliament the powers to remove the President. The fact is that that is the power that Parliament has already. So this is a power that Parliament has already. The procedure is laid out in the Constitution. So all we're saying is that if a sitting president or vice president loses his or her membership in the political party that supported their candidacy, doesn't mean that they automatically cease to become president or vice president. It means the procedure laid out in the Constitution already will be triggered. So that way, it is not left in the hands of the president. The option for this will be to continue with the current system, wherein the president can determine whether he or she wants to continue to work with the vice president or not. That is the current system. But then to have that additional oversight as laid out in the Constitution is the right thing to do. It's something that we discussed extensively on the tripartite committee and then laid out. And I think, when I say that we should all take ownership for these proposals, these are the things that I mean. That, when they come up in the public discourse, persons who have been part of this process should not be isolating these proposals. I think we should all state why these proposals are included. So that is really what we explain as a gap in the Constitution. So that the provisions apply. This was in the Cowan report after extensive consultations. This is a recommendation that the Cowan committee made, and that is why we have included it in this bill. And then we come to the preferred electoral system. I like to say, as Honorable Deputy Speaker of Parliament said today on radio, it looks like it's the elephant in the room. Again, I was very intentional when I said earlier that the tripartite process was not meant to undo existing government reforms or commitments. But what we have from the process that has gone through the hands of successive governments, which is the main constitutional review process that we've been engaged in for over 20 years, the Cowan Constitutional Review Committee, after broad consultations, I gave you the figures. After broad consultations, after looking at best practices in various countries, recommended that this country must transition permanently to the proportional representation system.
Yes, sir.
And it is in the white paper. I also like to say
Honorable members,
There'll be time for debate.
please, I continue to have your attention.
I also like to say that I like to go to the Women's Manifesto because it's an important document. I like to hold on to it. When women's groups commended government in that manifesto, that 12 of their proposals had been included in the government white paper. One such proposal was this. Matter of fact, I like to quote it. They say to ensure peace and cohesion in Sierra Leone, the proportional representation system must be entrenched in the Constitution. So these are processes, and so we acknowledge that every electoral system has its own challenges. We acknowledge that yes, the PR system in the last election had its own challenges. Yes, since we transitioned to multi-party democracy from '96 to now, we have had 6 elections. In 3 of those, we have had the first past the post, which of course has had its own problems as well. In 3 of those, we have had the PR system. In '96, we had the wartime model, we like to say, which means the entire country was a single block. And then 2002 and 2023, we used the district block representation system. So just going by our example in Sierra Leone is to say there are different variations of PR. So I think what this is supposed to do is to rally all of us around a table to have real, honest, technical discussions on what kind of PR will work for Sierra Leone. Of course, it has its own challenges. I've gone to communities where persons have said that they were not involved in determining who gets on the list to represent them in their districts or constituencies. That is a challenge that we must address. There are options to address that, right? So let's have all of those discussions. But we also acknowledge that having to deal with the problems that come with by-elections is challenging for this country. The violence that we have to deal with, the economic impact. Matter of fact, since 2023 to date, government has actually saved over 20 million leones, or if you want to put it in the old currency, 20 billion. If you want to put it in dollar terms, it's close to $1 million just by not conducting by-elections. And those are monies that government has been able to direct towards free quality education, and food security, etc.,
Please allow the minister to finish, please.
All right. We look at these processes. Like I said, recommended by the current committee after all of these processes, and then of course through other mechanisms. Now, how does this compare to the tripartite process? I think it's good to also put that in context. Now, the thing is, the tripartite committee, in the report that we submitted, of the 80 recommendations we agreed on, we did not recommend one system over the other. Yes, we discussed it in the tripartite committee, but right at the onset, we knew that we had opposing views on that process. And so what we agreed on and put in the report was that we should convene a national dialogue on a preferred electoral system for Sierra Leone. That's what is in the report. And then, of course, the government took that recommendation very seriously. We agreed to conduct the national dialogue. But because we wanted the dialogue itself to be really participatory, we added another layer. We said, before we get to the national dialogue, let's do countrywide consultations. And so we had expert facilitators, 3 of them, and then other actors who supported the process, international idea with funding from the European Union, and then we put a team together to support this process. That led to consultations, regional consultations across the country, and then that led to the national dialogue. Now for the national dialogue, after the national dialogue, a report was prepared. We received the report. We made the report public last year. We shared the report with various stakeholders. So you say that report is actually the product of the approach that the tripartite committee recommended. But then in that report, the report does not state a preferred electoral system. It does not state one system over the other. The report, in summary, says there are certain people, a significant percentage, that supports the first past the post system, and these are their reasons. And then other set of people, a significant percentage, that support the PR system. But then, noting that if we go with the PR system, we should reduce the threshold. And that another set of people prefer a hybrid system as is applied in certain countries. So that is what we got from the national dialogue. Now, it was going to be unrealistic. So now say, all right, the national dialogue has not given us one system over the other, so let's go back to tripartite and go get into a disagreement. We looked at it as though, yes, people have preferences for the various mechanisms, and that there were existing recommendations from the current process. As noted again, the tripartite process was meant to complement the current process, not undo or override it. And in the current committee report, which was accepted in the white paper, it was recommended that we transition to PR. So if the tripartite process didn't make a specific recommendation on that, we will go with what is on the table. Now, that is why we have this. Now, I think another thing that I should take this opportunity to clarify is there's been in the public domain, and also I think presented by leadership of our brothers and sisters in the APC, that the civil society, there's a civil society report or exercise that lays out the percentage of persons who support first past the post at 57, and over 30% support a hybrid system, and that 10% support a PR. And that these persons or the civil society representatives took a vote at that meeting. First, for disclosure purposes, I attended part of the meeting. I delivered the keynote, and I think it's an engagement that I welcome, and it's an engagement that I will welcome on the provisions in this bill as we move forward. I delivered my keynote, I left. I know that when my comrade got the mic at the time, I think his first complaint was that all the speakers had spoken in favor of PR. I think, they had to make the record straight. But now, I provide this context to say that those figures that several persons have talked about, including the leadership on the APC side, maybe they have seen the report. I have never seen it. And I think as a person who was managing the national dialogue, my office was managing that, I think the understanding was that the report will come to my office and then we'll discuss it. But as I say, I cannot speak to that as to how we got to those numbers. I cannot even make any judgment on those, etc., because they have never been before me. And so if you ask me why that data or the outcome of those deliberations were not considered in this, it is because, in all honesty, they were never before me or before any member of my team. And so, you can't consider or take on board something that is not before you. And so we went with the Cowan recommendation. But we also note that PR has its problems. Like any electoral system, of the more than 100 countries that practice some form of PR, actually by data, majority of the world's democracies actually practice some form of PR. In fact, there's data that shows that in a lot of countries where people are happy with their governance system, they have a PR system. So for me, the question is, how do we, as a country, get together and discuss the PR system that will work better for us? And so that is why, because we do not have the answers, that is why we have proposed that, yes, elections will be conducted through a system of proportional representation, but we want greater discussion on the mode, the method of nomination, and the conduct of such elections. We all want to get around the table, discuss, and come up with a model that works for Sierra Leone, and then that will be prescribed in a separate law by Parliament. So yes, we've done half part of it, but then I think let us all get together and do the remaining part. But really, when you consider the processes that various governments have managed and where we are, yes, we believe that maybe we should now transition. In our discussion, we should now transition to the kind of PR that we want as a country. That is the discussion. But again, it's a proposal that we've made to Parliament. Let us all discuss it and see first if Parliament agrees that PR is what we'll go by, and if they agree, we all get a discussion as to the kind of PR that will work for this country. And this, what we have here is the provision in 76(1) on whether dual nationals can run for Parliament. Yes, both processes in Cowan and the Tripartite Committee proposed this, right? But we note that it has been a challenging subject for our members.
Order, please. Order, please. If you want to have discussion different from what you are doing, please, you can move out and do so. We need to listen to the presentation. And he's doing a very, very good job for all of us. We can use this in our debates. But undertone are so loud that we can't even understand what he's saying now. Yeah, with the big one. Go ahead.
So this was actually meant to amend Section 76 and make it possible for our brothers and sisters who have spent time in other countries and during this period have obtained the nationalities of these countries, but who still remain Sierra Leoneans by virtue of our amended Citizenship Act, to be able to run for office if they so wish. But yes, we understand that it's a challenge, but then the impact that this provision has is, as currently framed, when it applies to members of Parliament, it also will apply, as has been argued, to persons serving as ministers. And so, of course, the presidency, I think, will be very clear. We discussed on the Tripartite Committee that for the presidency, it should be secret. If you want to run for president and have a nationality of another country, you should let go of that nationality. But then for all the positions, I think we even suggested having safeguards, which is, one would be, if someone wants to run for office, you should provide proof that you have been physically resident in Sierra Leone for like 3 years or 5 years, in Sierra Leone, as someone will say, as someone will say, SO2, make all consider if you are on for office. So, but what we're saying now in this bill, this is an option, but the other option is that if there's a restriction on running for office, that restriction should not apply to appointment as minister. So that is in the bill, but we'll discuss that.
Order.
So also there's a provision in our constitution that says a public officer who intends to contest an election should resign from such office at least 6 months, at least 12 months before the election. On the tripartite committee, we discussed this extensively, and it was our proposal so that be reduced to 6 months. But then, as government, because we want broad participation, we included another layer, because the question has been, what's the problem that we're trying to solve? And I like to give the example of the teacher or the healthcare worker who say in their community, highly respected, mentors to so many people in that community, and they are the persons that community really trusts to represent them in parliament. By this provision, we basically say such a person, I'm a teacher, whether secondary school or primary school, we are asking them to live in poverty, not be able to take care of their families for 12 months before running for an election. And so we consider that as government, and so this place should be open. So in addition to reducing it to 6 months, in the bill, we also made some modification. We have amended the Anti-Corruption Act. Before now, everybody was required to declare their assets. But then we amended the act to make it a requirement for persons at a certain grade to declare their assets. And so we are proposing that this requirement should apply to persons who fall in that category, who by the Anti-Corruption Commission Act are required to declare their assets. But other persons who are below such grade and are not required to declare assets, such as like a teacher or healthcare worker, this provision should not apply to them. That is the proposal that we have made. On the tripartite committee, we also wanted to make emphasis on the neutrality of security forces during elections. And so that is why we proposed an inclusion of language in sections 155 and 165 of the Constitution, having to do with the security forces, the police and the military, to say, one, in the exercise of power and their powers, they will not act in a partisan manner, will not further any interest of a political party or cause, will not prejudice a political interest or political cause that is legitimate under this Constitution. So that has also been proposed as an amendment. We have 165 minutes to go. So I really think these are. So these are the proposals that we have worked with our drafting team to put in this bill. And as I said, they are from these two sources that I've explained. And I'd like to close by emphasizing again that this is a bill. It is a bill for a reason. It is not a perfect document. We want to have broad conversations. We want to have broad discussions and really make sure that what comes out of Parliament is significantly better than what we have submitted to Parliament. I think if we all work together, we can make this something that will work for Sierra Leone and will really strengthen our governance and electoral architecture in this country. Thank you, Chairman and leaders of government.
Thank you very much. Thank you very much. Again, yes. And now with the, I'm happy my Archbishop is here because at this point I think I would like to quote from the Bible. I think Matthew 22:14. Many are called. So, again, not all of us will be able to ask questions. But like the AG said earlier on, the conversation is going to continue. This is a proposal. It's our collective responsibility to make it a document for the people of Sierra Leone. So now, we're going to open the floor for questions. And we want to encourage MPs, because earlier on I told you to carefully take your notes. And this is the time to ask your questions. The floor is open. Just raise your hand in different segments. Just raise your hand.
Mr. Chairman. Mr. Chairman.
Yes. I want the mic back because you don't have to give the mic when I haven't given the instruction who to give the mic to. I'll be mixing it. MPs on the left and of course key stakeholders on the right. So I'll be mixing it in that particular manner. Yes, the chairman, PPRC.
Thank you very much, Chair. And very good afternoon.
Yes, I'll give you 2 minutes.
Chair, let me start on existing protocols. I'll go straight to the proposal to amend Section 34 of the Constitution as it is right now. Care must be taken to actually fully understand what the Attorney General and Minister of Justice said. The Justice Cowan review of the Constitution had been concluded but was yet to be adopted. And between that time and today, we had our Act, the Political Parties Act, repealed and replaced in 2022. You realize that the change of name for the PPRC was a desire to actually give it regulatory powers. But that one has been called in the 2022 Act. Remember, it is now Political Parties Regulation Commission. So it now has the power not only to register, because regulation includes registration, not only to register, but to regulate. So I would say with humility that that which was sought to be called or to be addressed in the Justice Cowan review of the Constitution by making that particular recommendation has been called, and therefore there is no point changing the name from PPRC to PPRRC or PPPRC. because it has been now resolved. Now we have regulatory functions, and regulation includes legislation. So it will be repetitive to now call it the Political Parties Registration and Regulation Commission. So that change of name, I'll request be considered in your debate in the instant circumstance. And of course, in regard to the issue of political parties, who, when they lose elections, should be deregistered, which comes as a proposal. Political parties are not our clients, they are our partners. So the political parties will have to make a representation in that regard. Thank you very much.
Thank you very much, Mr. Chairman. I've taken one from this end now. I need to go to members of Parliament. Honorable members, you are representatives of your people. It's a bit strange that I haven't seen your hands up. Honorable Timbo.
Thank you very much. I don't know if the minister is still around. Is there? Yes, sir. Firstly, I want to commend the Minister of Justice for quite a passionate and statesman-like opening statement, and that this document we're dealing with should look beyond politics, should look beyond political parties, and we know that constitutions are not made just for the short time but for even the long term. I will not go into specific provisions because this is just the start of the process. And as a member of the Legislative Committee, I have a lot of things. My party has a position also which we'll present within the arguments. That's what we will leave when we're dealing with the document in the Legislative Committee. However, I have 3 points. Firstly, the Minister of Justice has been really transparent in the things he said leading up to this point, talking about the engagements they've had, the inclusion of many people in this process. But one thing he said is that this document contains some recommendations from the white paper, the Cowan report. And like he said, there's been developments now. As it is, I don't know how popular this white paper or the Cowan report is, how much it is in circulation. So as this document is out, the bill is out, and the tripartite report is also out, I appeal to you to make the white paper or the white papers and the reports of the Cowan Committee also known to us. Because if you make a reference to it, we want to compare it side by side. As you said, this document has nothing extraneous, has nothing new. We want the the Cowan reports to also be made available to all of us. Secondly, you made mention of certain things in your presentation, particularly in the provision for the amendment of Section 35. And from the document that we have, the bill that we have, some of the things you said, I haven't seen in my copy, the one I printed myself as well as the one that was given to us. We just want to know whether the one that has been circulated is the final version. For instance, Section 35 that talks about deregistration of political parties. I haven't seen that in the bill that I have.
No, you say your party.
Yeah, proceed.
And finally, I want to make legal reference to what The Minister of Justice also spoke about entrenched clauses, particularly 1083 of the Constitution. And I want to say I beg to differ in saying that while the bill will still be presented to the President, but the provisions that are entrenched in the Constitution will not. By the letter of the law, that is not what Section 1083 says. Section 1083, with your permission, I'll read. It's very clear. Section 1083. I read. A bill for an act of Parliament enacting a new constitution or altering any, the emphasis is on any, of the following provisions of this constitution. I don't want to repeat all the sections, but you spoke about section 85, 87, which are entrenched clauses. And it says, shall not, that's the bill, shall not be submitted to the President for his assent and shall not become law unless the bill, not unless the provision, unless the bill. The bill is one holistic document. It is not a provision. Unless the bill, after it has been passed by Parliament and in the form in which it was so passed, the bill in its entirety, in the form in which it was so passed, has, in accordance with the provisions of any law in that behalf, been submitted to and been approved at a referendum. This does not refer to a section. It refers to the document in entirety. So I understand where the leader of the opposition is saying we will kick against any provision that touches or concerns entrenched clauses in this bill, because this document should be taken in its entirety, and this is my submission. Thank you.
Thank you very much, Honorable Mfakuruma.
Thank you, Mr. Chairman. Mr. Chairman, honorable members.
Order, honorable members, order.
We definitely want to appreciate this document that is in front of us. And I'm happy that the whole country has an opportunity to see what we have been confronted with. My question and the issues I want to raise are with section 32 that speaks to section 3, in which an electoral commissioner should be appointed. We know with elections in this country, we know there are issues that are very political. And I always hold this view that to fix a political problem, we need a political prescription. So, in recommending electoral commissioner to the president, it is a political problem that demands a political solution. Though we believe that interreligious community should be included, though we believe that the Labour Congress should be considered, though we believe that youth groups and women organizations should be considered, we also believe that politicians and political parties should have a say in the recommendation of an electoral commissioner to the president. We cannot leave politicians out of that equation. So for us, I believe that is something that needs to be revisited and reconsidered, so we can have something that's cool in the future, will not be controversial. Because we know as a country, we all have respective political lenses. And if that is the case, we can choose respective people in all these organizations, but they possibly will have one political lens. So that is why it's imperative that we all consider including political parties in this equation, because this law should be able to stand the test of time. The second part of this one, Mr. Chairman, is the area that has to do with census before elections, or what census results we should be using. I'm glad the Minister, the Attorney General, Minister of Justice, said they are open to proposals. And it is critical because now we know we have a census that is going to happen 2 years before elections. And we've not had a census, a national census, since 2015. Though we had a midterm census, but we can recall that in that midterm census, it was not accepted by even ECSL at the time when the Public Elections Act came, or the bill came to Parliament, which caused the ECSL to recommend that we have a prescription for that election in which there was an average done for the people that were counted. So if we're going to have an election and a census, though this law could be the law to stand the test of time, but these elections and this cycle should definitely be an exception in which the results from this census should be considered for the next election. And I must go on record to say that the APC has fully supported the census, and the APC will fully support the census. I know I don't have enough time because I want to give the platform to other speakers.
Thank you.
So I'll just end on 42(2)(e) that talks about elections and the majority of what will be considered in that election. So for the 2(e), for the listening public, it states that no person shall be elected as president of Sierra Leone unless at the presidential election he has polled not less than 55% of the valid votes in his favor. I will say, and I will conclude, that there is no reason. There's a common saying that says, if it's not broke, don't fix it. The 55% is not broken. So let us now endeavor to change that. Because the 50 plus 1 and the 20% as proposed in this bill has other rooms for other issues that we will struggle with as a nation. So definitely, I believe that the 55% will allow even political parties to come together, though this bill is also proposing the registration of political parties, which the APC do not support and do not agree with. We believe all political parties should have a say in the elections of this country, especially it has to do with representation. We believe 55% should be the one that should stay in the books, and 50 plus 1 and the 20% will not be one that will stand the test of time. And it will not even survive under the PR, which I believe somebody else will talk about. Thank you, Mr. Chairman.
Thank you very much. Now, one more from this end, and then AG will respond. Yeah? Order.
Thank you very much for the opportunity, and thank you for making us be part of these.
Order, honorable members.
Thank you for making us be part of these deliberations. Actually, being here, I am more reassured that we're going to have a constitutional review process that is transparent and that is open. And I want to commend my darling, the Clerk of Parliament, in reassuring us, and members of the High Table that have indicated to us that we're going to have a constitution that is based on consensus and consent. We're going to hold you to that promise. Now, I am not going to go into the position statement of Oraj because I know that you already have it, and the AG has already promised, and the clerk has already promised that you're going to look into it and take some of it into consideration. I just have some observations based on the presentation of the AG today. I would like to draw your attention that contrary to your presentation on Clause 1 of the constitutional amendment, you made a reference to the mandate of the Search and Nomination Committee in your slide, but I would like to mention that it's not in the bill. Should I repeat? I know that you made mention in your slide of the mandate of the Search and Nomination Committee, but that is not mentioned in the bill. Secondly, you did mention and you emphasized that this bill is consistent or is a product of the Cowan recommendation and the tripartite recommendation. There's nothing there that is government creation. I must say, with all due respect, that is what has created the confusion. That statement is what has created the confusion to the public. Because upon closer scrutiny of the bill, juxtaposing it with the Cowan recommendation and the tripartite, you will indeed see that there are deviations, some of which are partial, some of which are outright. So, in order to reduce the tension and the confusion and the controversy, I would most respectfully advise that you don't have to justify that it is exactly the same like the Cowan recommendation and the tripartite recommendation, because that is where you create confusion for all of us, because it is not. Also, AG, even where there are alignment, even where you say even where you say there are alignment between the Cowan recommendation and the tripartite recommendation, and that's the reason why you adopt some of these provisions and you call them mere modifications. They are actually, in fact, a creation by the government because they defeat the purpose of the values of the tripartite recommendation, which is inclusivity, participation, and sovereignty of the people. I can give you a simple example. For example, Section 32, we are seeking to amend.
Honorable members, this is an opportunity for us to clarify things here. Let's grab that opportunity, please.
For example, Section 32 that we're seeking to amend with reference to the appointment of the of the chairman of the Electoral Commission. The tripartite recommendation says that the members of the Search and Nomination Committee must be administered by the Public Service Commission, must be established by the Public Service Commission. However, we have given the power to the president to appoint, which means even though it is partially aligning with the tripartite recommendation, it is deviating from the intent, which is to reduce the discretion of the president and to insulate the Chief Electoral Commissioner from executive interference. So when we say that it is not government creation, we should be careful, because if you change the rationale behind the recommendations and the intent behind the recommendations, it comes across as an imposition. And one last observation that's got to do with clause 9 and 11 of the bill, quickly. They seem to contradict each other. On the one hand, the AG has explained here that we are not introducing a new ground to remove the president when he is expelled from a party or when he resigns from a party. But it is categorically there in clause 9. It seems like that is what we're doing. We're increasing another ground or adding another ground for removal. Yet, clause 19, which talks about the vice president, which is similar to clause 9, says that it should be subject to section 51 of the 1991 Constitution. And by the way, that recommendation is contrary to the Cowan report and is also not in the tripartite recommendations. So again, we have to look into that, because if we leave both of them in the bill, it will create confusion. We'll have to decide, are we going with clause 9 or are we going to clause 11? Because clause 11 seems to amend and remove the effect of section 50, and whilst clause 9 seems to retain section 50. Thank you very much.
Thank you very much, and I'll now call on the AG to respond. Honorable members.
Please, honorable members, please, this session is very important. Let's control our attitudes. Thank you, colleagues. I'm hoping that we will have.
Hold on. Again, this is a gentle reminder that we're representing the people of Sierra Leone. We can't bring all of them in here, but some of us are privileged to be here representing them. Let's represent them to the best level. Thank you.
Thank you. Like I said, Chair and leaders and members of Parliament, I'm happy that we're having this conversation, and I'm glad we all make a commitment. We've all made a commitment that this will not be the end of it. I think, outside this room, we will also have these conversations with various actors, conversations that are not, just convened by members of Parliament. So we really get into the technical details of some of these proposals. I'm happy to discuss with the chair of the PPRC. But the point is that yes, in the Act we have said political party regulation commission. Now the point is the recommendation is to be very clear, because registration and regulation are two different things, right? They're two different things. To register to take responsibility for registration of political parties and then take responsibility for regulation of political parties are different. But we'll have that discussion, and then we will figure out together whether we go with the recommendation that you will be very specific on the registration mandate of the commission, or whether its work is covered in its regulatory mandate. So we'll discuss that. To my brother and colleague, and to add another comrade of the Radicals Club, Honorable Tigo, our numbers are the opposition APC. First is to say that yes, these documents, as much as yes we say they have been public documents, we will do our part to share them again. Matter of fact, the Minister of Information and Civic Education is here, and we have been working together on a very robust public education program. He likes to correct me because we don't want this to be just information sharing. We want a process that we can call an engagement with members of the public. Yes, we want to listen, we want to learn, and we want to incorporate feedback into this work. And so, as part of that public information strategy, this week actually, we will be today. He has said today actually, we will be launching a website for the constitutional review process, and so everything will be out there. The documents that we have referenced here will be out there, and so you have our word that these documents will be available. I think we seem to have a disagreement on our readings of Section 108. Respectfully, I think our readings, but I think I'll engage but not preempt, how you will look at it in the legislative committee. But I think our readings of it are different. I'm glad that my colleague and sister, Mrs. Michael, spoke about the letters and the intent. I think, we'll have to go into what the intent was. But it is just to say that we know that at this point, we don't really know the form in which this is going to go to the president, right? Or the form in which it is going to come out of Parliament. But that form will actually, determine what goes to the president or what becomes part of a broader package for a referendum. But I think is to say respectfully that our readings of it, taking it that it has to be in a separate bill because of the use of that word, is very different. But we can discuss that as colleagues, and make sure that when it gets to the legislative committee, I think we are all on the same page. Yes, and on the appointment of the ECSL chair, I take your point, Honorable, that political actors should be included in the process. I think when we discussed this on the tripartite committee, we did not consider that. The idea was to really take that decision-making process from the hands of the political actors. I think we tried to look at the Kenyan model in which the search committee appoints the chief electoral commissioner, and then what we try to get like a blend with our own system, where you don't take out the president's powers completely, but to say yes, the search committee will do its part, and then you'll recommend to the president, and then the president will select from that group. But this is a discussion that we should have, because you're not the only one who has said so. In discussions with the other political parties, the All Political Parties Association, or let's say the other 15 political parties, they also expressed the same concern that political actors have been taken out of the process. So I think this is a discussion that we should have, and again, I emphasize that is why this is a bill. All of these discussions should really enrich, the outcome of this exercise. So by all means, let's have. So we'll talk about that. Census results to be used. I think we have made our own proposal on how that clause should read. Whether we have a transition clause in there on when it comes into effect. I think let's discuss that. But again, it's before you. We're happy to discuss all of these options and come up with something that will work for all of us. Section 42, I think we'll discuss, but I think there's really broad. When the Cowan committee looked at it, when the white paper discussed it, when we discussed it on the tripartite committee, yes, it was our view that it's broken. It has problems, and really, if we look at best practice, in the region, we struggle to find a country that still uses that system. So we also took note of the challenges we've had to deal with when we're going to run off elections, and say, yes, what we propose now does not eliminate the chance of a runoff completely. It's still possible, but it reduces that chance substantially. So let's have that discussion as well. To my colleague, Mrs. Basita Michael. So, I think I like to say respectfully, when we have audiences that listen to us, I think it is good to do our part in getting the information right so that we send to them. Because in this day and age, you say one thing, yes, just like me, right? I say certain things, people will question. But then there will be people who will move on with that. So when we say certain things and try to state them as authoritative positions, I think we should be careful. What you state about doing this, I can't quote your exact words, but within the Public Service Commission, the process that we set up through or within the Public Service Commission, that is not true. That is not what recommendation 36 says. 36 talks about yes, the search and nominating committee for the appointment of Electoral Commission and chair of the PPRC, right? And talks about 9 processes, including one from each. It lays out Interreligious Council, Bar Association, Civil Society, Labour Congress, Sierra Leone Association of Journalists, Women's Organizations, Youth Groups, and the only mention of the Public Service Commission is that the search and nominating committee to be supported administratively by the Public Service Commission. I think let's be very clear the way we put this. It is an administrative support. The Public Service Commission doesn't even have any role in the constitution of the body. So let's try not to give that impression to members of the public. It only says the search and nomination to be administratively supported. It's just to provide an administrative support. It has nothing absolutely to do like its constitution and the way it carries out its mandates, etc. It's only to provide administrative support. So I think let's be very clear on that, and I think let's be very careful in the way we communicate these things. I still want to say, in the spirit of the same comments that I have made, the way we communicate this to other people, I like to hold myself accountable. And I have been very clear. The moment this was put together, since last year, I started saying that a few of the proposals have been amended. I was very public about that. These are not things that have taken place in hiding. And yes, you might say that when you amend certain proposals, you might alter the intent. That is true. That is true. But I still go by what I have said consistently since last year, that the proposals in this bill are not creations of government. They are creations of these two processes. But I have said that there are certain proposals that have been amended, but that is how government functions. So now, let's put it this way. I've been in government a few years. I'm still learning, right? And you know, I learn from people in government. I learn from people who have served in government. In fact, next to you is my big brother and partner. We call ourselves a partnership on the tripartite committee. When we served on the tripartite committee, and sometimes when things were difficult to handle, the entirety of the committee would put it in the hands of myself and Dr. Richard Conte and say, you are the partnership, get a solution. And we will hand heads. We will look at options. We will engage various individuals on our respective teams. And then we'll come back with proposals. Most times, the entirety of the committee will adopt the proposals that we bring. But during this process, noting that, you know, he has, of course, lived in this world longer than I have. He has served in government in various roles, in the office of president and, you know, in various ministries. I've had to learn a lot from him, right? Same with Dr. Mara, I used to say so. So I'm still learning. So, but one thing that I know during this time that I've been learning is that when bodies make recommendations, they are called recommendations for a reason. They are not called directives. They are called recommendations. If you go back to, let's even take it to the Truth and Reconciliation Commission report. When the TRC issued its report, handed the report to late President Kaba in 2004, there was a white paper. And then, of course, we saw with other commissions of inquiry that we have set up. The Shares Moses Commission of Inquiry, inclusive. And then, you know, you come to the Cowan Constitutional Committee report 2017 white paper. And then you come to the 2022 white paper. If you read these, you will find three common things. One is government rejecting some to say we cannot do this. That's deviation. But two, government accepting these recommendations. And three, government accepting with modifications. That's how government functions. Check the various white papers. That's how. So it is okay, government will accept with modifications. Yes, those modifications might affect the intent of the provision, or they might alter the outcome in certain ways, right? So and the point is that we have not hidden away from this fact. I came out publicly before anybody could point it out that yes, there are certain proposals that have been modified. I discussed this because that is how governments function, right? And so now that we have had these modifications, we have laid them, yeah. We have again said that even on these proposals that have been modified, we want to have additional discussions. Let us use these discussions to determine whether we keep them in their modified form, or we take them to the original proposal, or we get rid of them altogether, or, you know, let's just say how we make the provisions better. That is what we should do. And I think that should be part of what we communicate to our audiences, especially when we know that the room is still open to have these discussions, instead of, putting it as though, certain people have taken certain positions, that are completely out of the way. I think the way sometimes, these are received, they undermine the processes that we are all trying to make better. So on this, again, you have my word, and I know I'll speak for government on this, and buttress the points made by the leadership of Parliament, that we are open to having discussions about this. We are open to looking at different clauses, looking at variations. There are proposals here from the tripartite and Cowan processes that we might even want to review and make better. So let's have these discussions. I think it's an opportunity for us in government to learn from you. It's also an opportunity for you to, get the rationale for certain things. At the end of the day, we'll find common ground. No guarantees that we'll agree on every letter, but I think we'll make significant progress and find common ground to really produce something that will be good for the people of this country. So please, we have not attempted to defeat the purposes of this. We have good reasons for the modification. I think even in the bill, when we said that the president will appoint a search and nomination committee with representatives from these various bodies, yes, maybe we need to make the language more direct and say these bodies will nominate their persons, right? Maybe that's what we need to do. Maybe it's a language. Maybe we will say, if you go to the Agreement for National Unity, Clause 3 of the Agreement for National Unity, Clause 3 actually says the President will constitute a cross-party committee for electoral systems reform. But how did we interpret that? The President actually asked the opposition to submit their names. That is what happened. It did not translate into the President making the individual appointments. So clearly, yes, let's not leave it open to ambiguity. Let's make it better, and so we'll work together. But I'm just grateful for your feedback, for your very kind comments, and really happy to work with you on this.
Thank you very much, AG. Honorable Mohamed Bangura, Honorable William Slamin, and Honorable Mama Zombo, in this order.
Thank you, Mr. Chairman. First of all, I would like to commend the AG's office. Am I protected?
You only use that protection if you talk beyond 2 minutes.
First of all, I would like to commend the AG's office because this bill is less controversial the way I've seen it. But let me...
Order, honorable members.
Let me bring you section 42. 1. A presidential candidate shall either be nominated by a political party or an independent candidate. I will want you to put a caveat on this. That provided short individual was not a member, a registered member of a political party for 2 years. 2 years. For 2 years. For 2 years. And also, I would just want to support Dr. Ompa. When you make laws, you said the president or the select committee must appoint members of the electoral commission. But you failed to bring the most important players, members of political parties. They have to be included. Members of all registered political parties have to be included. They have to be included.
Order, honorable members. Your attention, please.
And also, lastly, Mr. Chairman, well, that position has already been supported by the government from the AG and from the opposition. Well, let me just the position. By the opposition. I am PDP. Let me tell you.
Order.
You know what, Mr. Chairman? I'll wait for the minute.
Thank you very much. Honorable Williams Lamin. Remember you have 2 minutes.
Thank you very much, Mr. Chairman. Mr. Chairman, members of the High Table, I stand on existing protocols. I want to take this single opportunity to say thank you, AG, for the concerted effort in putting this document together. But my concern here is for
honorable members.
This clause 8, section 43 of the Constitution. On the side note, it says period during which presidential elections shall take place. On clause 43(1), the presidential elections shall be held on the second Saturday in November in every 5th year. My concern here is that we have a very accommodating atmosphere in Sierra Leone. We have 60% of our population are Islamic and 40% is Christian, and the 40% Christians, they are 10% over are Seventh-day Adventists in Sierra Leone, who stand on over 125 years existence in Sierra Leone, who have contributed immensely by having, like you said, I use your word, discussions. If we have discussions around the day of the election, will help us a lot, so that 860,000 members of Sierra Leone population will not be discouraged to come to the polling booth at that time. Because if we are talking about 8.6 million people in Sierra Leone, and about 10% of that population are worshippers on Saturday, I want us to discuss the issue of if we can move that day from Saturday to Thursday. That would be my take. Thank you.
Thank you, honorable member. Your point is well noted. No, in the first order, earlier on I said Honorable Mohamed Bangura, Honorable Williams Lamin, Honorable Mama Zombo, then I'll take different, I'll take other set of people. Yeah.
Thank you, Mr. Chairman. All protocols observed, I would like to comment on section 76D, which speaks of the qualifications for being an MP and those that will exclude you from being an MP. I would kindly ask the House to look at the rape and sexual abuse part. I think it should read sexual offenses, because sexual harassment is a major form of, it's a crime. And there are people who harass women, particularly. That is a crime. So it has to be sexual offenses. There are different kinds of sexual offenses. So let's not limit it to just rape. Women and men also. And I would also like us to look at cybercrime. cybercrime, this is criminal. And if someone has committed cybercrime, that person or consistently commits cybercrime, that person should not be a member of parliament. And also contempt of parliament. If you are in parliament and you have committed contempt of parliament severally, then you are not qualified to be a member of parliament in the other section. Women and men. I'm speaking about women and men. And also drug-related offenses. If you have been convicted of drug-related offenses, then you are not fit to be a member of parliament. That can exclude you. Secondly, I'll speak of the PR system, section 74, subsection 1. I am calling on all women to support this section, this addition. We are here today, and this sudden surge is because of the PR system. Majorly because of the PR system. So this is not about party issue. This is about us being here and more women being here. We want to have up to 60%, if possible, of women in the House of Parliament. We have already set the stage. They have set the stage in Africa, globally. So we want to continue being here and have more women here. Let us support the PR system. Don't even look at the parties. We are not going to rely on parties. Let us support women, please. And men who are she for his or he for she's. He for she's support us. The PR system's advantage is big. And apart from it being a peaceful system, because we have seen this, there is no problem with replacing people in parliament. We know that it's going to increase the number of women. Let's stop entrenched male dominance and patronage.
Alright, we have 30 seconds.
And the party list, we would rather have a fair alternation. Let's start with women. One woman, one man in the same system. Thank you very much.
Thank you very much.
Yes, basically, yes. Honorable members, of course, once this document has been laid on the table of Parliament, it is our document. So for the amendment, we'll have ample opportunity as members of Parliament to amend it when we get to committee stage. This opportunity is only for us to give our overview idea on the bill. But to get into the bill proper, we'll do when we get to committee stage.
Okay, thank you very much. Leader, on that note, I'll take two more speakers. The Mayor, Ivana Kisoya, and Dr. Emmanuel Gaima. I close the session. Thank you.
Thank you very much. AG, let me use this opportunity to thank you for an excellent presentation, very detailed, and to say thank you to the Parliament for providing this opportunity for us, the members of the public, to be part of this pre-leg event. One of the things that's been said by the AG a number of times today is that government has the imperative or the prerogative, shall I say, to make their own decisions, to take recommendations, either take them in full, reject them, or tweak them. I'm really pleased that we have a system of governance wherein we have a legislature who, as parliamentarians, are representing their people right across this country. They also have the objective, or they have the opportunity to take what government has presented and to make changes. So we expect that this is going to be a process, as Chairman has said, as Leader of Parliament has said, and as Honourable Abdul Karim, Leader of Opposition, has really put on the table that we're going to have a fair process when it comes to the vote. We know that 108 says 2/3 of members of parliament, not 2/3 of those at parliament on that day. So we're looking forward to seeing these sorts of issues addressed properly. The other thing, the other point, hello, honorable members, if I may, Mr. Chairman. The other point that I'd really like to make, AG.
Order, please.
Order, honorable members. We are rounding up now.
You said the elephant in the room. You said the elephant in the room is the PR. It's the PR. It's the elephant. You are quoting the Deputy Speaker. The elephant has a twin elephant. The other elephant in the room.
Honorable members. Okay, hold on. Honorable members. Please, let's pay attention. Again, it's a gentle reminder that you're representing the woman from Calabar who is not able to be here.
Honorable members, please. Honorable members. Yes. There are certain stakeholders. We treat them in two categories. Please. All right. Please, for this purpose of the privilege. Please, honorable members. Please, honorable members. Honorable. This is Parliament, and there's order. This is Parliament, and there's order in Parliament. Honorable member.
Okay, Mr. Clark, just hold on, Mr. Clark, hold on. Honorable members, may I please have your attention? I don't think this is so difficult, especially in the interest of our people. All we need to do, let's just pay attention. We're not asking for too much.
Thank you so much, Mr. Chairman. Thank you so much, Clerk of Parliament. I really appreciate that. There were two more points I wanted to make. One of them is, as the AG said, the elephant in the room, as he described it, was the PR. And on the PR, I'd just like to make a point. One, that we are, as a woman myself, obviously very, very, very keen to see more female participation in governance at every level, from the presidency to the parliament to local government. But PR is not the only way to do that. So I'd just like to make that point. The second point I'd like to make is the elephant's twin. The elephant has a twin. And the twin is when the tripartite recommendations moved the threshold from 55% to 50% plus one. After a great debate from all there, it was agreed that it would be 25% in 50% of the districts. As you've said, the government has the prerogative to tweak, and you've tweaked. You brought the threshold down to 20%, and you said 2/3. I'd like to say that personally I think that's very concerning, and I'm very glad that Parliament has the opportunity to use this platform to take us back to where the tripartite recommendation took us, so that we come back to 50% plus one and 25% in half of the districts of the country. I'll stop there, and once more, I'm not part of the radicals. You begin to feel left out when you're not in the radicals, right? When these guys are talking. I'm not part of the radicals, but I think you're still going to take what I'm saying as your sister.
Thank you very much, Dr. Emmanuel Gaima. Order, honorable members.
Mr. Chairman, the National Parliament, the Honorable Attorney General.
Hold on. Again, honorable members, I'm pleading with you. We are almost there.
And Mr. Chair, I am following the comments on the live, and the public is so disappointed that on such a crucial time, members of parliament are so furious. Please, members of parliament, let's listen to the contributors. This bill belongs to us. We have a lot to say. We have a lot to do.
And that's exactly what we're trying to do. But then again, we have to conduct ourselves in a way that the strangers will be willing to trust us with their information. Yes, proceed.
Mr. Chairman, I want to stand on protocols. Just a couple of
Order, honorable members.
To sense. Dr. Dema is speaking. Let's listen to sense, please.
I had my sister make reference to the principle.
Hold on. Honorable members, is this really so difficult? Remember, we are all leaders. We're representing people from different districts. They are watching us on TV. If we can't pay attention to each other, how can we represent them? Proceed.
Chairman, reference was made to certain principles of the tripartite. To the best of my knowledge, those were principles we carved out in the tripartite as a mechanism to enable us to have the discussion in an environment where we have the opposition party and government representing government, constitutional and political parties. For future guidance as this process continues, one of the things we put a lot of emphasis on was country leadership and country ownership. That in whatever we are supposed or we are going to be doing as we move this process forward, we have to look at what is good for Sierra Leone and what is best for Sierra Leone. And closely linked to that, we also wanted, in the event somebody wanted to inject anything new, to look at where is jurisdiction coming from and whether that is really a globally accepted best practice. So that we don't have any utopian concept built into our system that cannot stand the test of time. So I wanted us to look at that one. Secondly, there was the issue of consensus. The 80 recommendations we have, we agreed from the outset, both from the APC and part of the government, that the recommendations to be accepted, there must be consensus across the group, from the government side and from the APC side. So I want to encourage members of parliament from both political parties that whatever is in there is actually coming as a result of what was agreed on by the adhering constituent representatives on the part of the government and on the part of the APC. Suffice to say, the other 15 political parties, and I kept repeating that perhaps we had 15 political parties that were outside of the room. But in the interest of the state and governance, we assume that those people who are representing government, including my humble self, we are representing all the 15 political parties. And the third one, which is really very critical, whenever we had issues that became extremely contentious and it was difficult to arrive at consensus, we differed. We said there should be consultation, government must consult. And that was the leading process. We recognize the leadership role of government, hoping that government will lead on the process. In the last couple of weeks, I've been hearing positions being articulated that CSOC. There was not a single time that was defined that it was going to be a CSO decision. We said there shall be consultation, which means the government shall consult. And so I just want to guide, as we go forward, that this is a product of consensus, 6 months of good work. We also realize that there should be country ownership and country leadership, but above all, where there are contentious issues, consultation must take place. What has been missing perhaps is we are yet to define within government what is consultation. In terms of what is consultation, what's the minimum threshold, what happens when there is agreement, and this is something I want to assure this House that government is working on speedily. Thank you very much for your attention.
Thank you very much. AG, AG, respond, and then we close the session.
Yeah, I think this one will be short. I don't think there's much some I agree with. I think on the issue of independent candidates you spoke about, yes, we have actually indicated that we're going to put certain conditions to prescribe a parliament. But I take your point, because we know when we say that the person should not be a member of a political party, it's actually to prevent a situation where, for example, someone loses flag bearer contest and then just transitions. So we had in mind 1 year, but I think discussing it whether 2 years would be better. I think that is something that we should discuss. The date for election, honorable, let's discuss. But I think previous elections have taken place on Saturday. But certainly, I think even the last election I think happened on Saturday. But let's discuss by all means and see what really works for. I agree with Honorable Zemo and PR, and yes, Parliament can discuss whether they extend the scope of disqualification. And then, of course, the Mayor and I have had a lot of discussions about PR. Why? I think because I have been out here. Like I said, no one system is perfect. But since we have mechanisms that have recommended PR and voting practices in other countries, I think let's have a detailed discussion on the kind of PR that will work for this country. That is why we've not prescribed any. Same with the threshold system. Yes, I know that we moved from 25% to 20%. Like I said in my presentation, we looked at it and realized that 25% in half of the voting district does not solve the problem, because the idea was keeping the country together, so parties are actually moving beyond their struggles and then getting a national appeal. That is why we said reduce the threshold to 20, but then broaden the scope. But certainly that is the discussion that we must all have. But whilst I have the mic, this is really, I just want to use this opportunity to thank the chair of the Legislative Committee as well as the leadership of Parliament for the opportunity to do this. And I want to also thank all of the members of Parliament and our civil society partners, other members of the audience. I'm really grateful for the input. I'm really grateful for the engagement that we have all had with this process. This is exactly what we anticipated. This is what we want, so that we can get something that works for this country. Again, nothing is set in stone. These are proposals. In some areas, there might be maybe interpretation issues or challenges with drafting or formatting, but let's all discuss and see. And really we'll find out that maybe the intent is not affected. You understand? If we probably look at we draft it again, but it's something is on hand to get input from everyone and really give us what we want. So by all means, please, let's work on this. But I also want to especially acknowledge the work that the Tripartite Implementation Secretariat is doing on these reforms, as well as other recommendations that fall within the 80 recommendations in the Tripartite report. Strong support on these reforms. We'll continue to do this work. They will also open their doors to engagement on these reforms, as well as on other aspects of the Tripartite report. Really deeply, I'm grateful for your time, and please, let's do this together for the people of Sierra Leone.
Thank you very much, AG. Before you leave, you understand.
Yeah, Mr. Chair, this is not a question, but I just want you to bear in mind just this. Like I said, I have expressed our unreserved intentions to cooperate fully. But again, this agreement was between the government of Sierra Leone and the All People's Congress political party. So to me, even in the preparation of the recommendations, government was fully involved at the highest office of legislation in government. You were there, you were part of the process. So I wonder why government would have appended their signature to certain recommendations, and at the end of the day, changes were made to those recommendations that were made in the presence of government's highest representatives. So please, I just wanted to be at this in line, Mr. H. If you want to reply, but that's just what I wanted to do.
Thank you very much. On behalf of the parliamentary leadership, I want to thank each and every one of you for your meaningful I want to thank all of you on behalf of parliamentary leadership for your meaningful contribution to this exercise. The discussion will continue and continue to reach out to the constituents, and by the end of the day, we know that what you bring to Parliament will help make this law that will stand the test of time. Thank you very much, and God bless you.